Our first speaker today is again Larry Parish. We would like to welcome him back to continue with his talk. Again, a little bit about him. He's been practicing law since 1968. He has never looked back. Currently, more than 50% of his practice focuses on clients with personal injury involving diseases due to toxic mold and mycotoxins. His cases have involved litigations, appeals, settlements in many states in Tennessee, Texas, Mississippi, and California. He currently owns his own practice in Memphis. He's been married for 53 years. I told this yesterday. I would like to repeat that today as well. He's blessed with 3 children and 10 grandkids. Please welcome Larry Parish.
Thank you. Well, I'm back, and you all are not helping me. I had thought, I was wondering, good night, all the experts are getting old, and I don't know where the young people around here. I took the last deposition Kay Kilburn ever gave, and then I just missed Marikovich and my toxicologist that I used who introduced me to a lot of this, Richard Lipsey. He just doesn't even go out anymore. He's just, he's living a nice life. He said, I'll do something for you, but you're the only one I'll do for. And Richard, when I met him, he may not be the best toxicologist in the world. I'm not sure. I know at least one that's better, and he admits that also. But he doesn't like any confidence, and you wouldn't know that he was not the best toxicologist in the world when you have him on the witness stand. and the judges love him, the jury. He's just an affable old guy. You just like him. So he makes a great witness, whether he's the best toxicologist or not. And I've crawled up in rafters with him, and he taught me where the mold is and where to find him. But everybody's getting old, and then I have come and I find there are young people. There are Xers, maybe even a millennial in this room, who seem to be catching on. And Dennis kept telling me there were people like that, but I hadn't seen any of them. And now you all got my adrenaline running again. And so I can't sleep. I woke up at 3 o'clock this morning just mulling over all this. It's still there. There are people still out there who are really interested in this. So I'm glad you're there. Didn't help my sleep a bit. My adrenaline's running. And my wife tells me, she says, I've been married to you for 52 years and I'm just finding out you have dyslexia. I said, well, what's the problem? She said, look, you are 75 and you think you're 57. You get those numbers mixed up all the time. And it's not helped because people tell you you don't look like you're 75 and you believe them. She said, you are 75 and you need to go smell some roses. But I'm pretty mission bound, and I enjoyed being here with you all and finding out that there's still a life. And so one of the things I'm mulling, I told you yesterday, we really need a big case. We need to have a big win. We need to have another $39 million verdict that sticks. And we know what the insurance industry is going to do now. We're ready for them. And I thought, how is that ever going to happen? And I thought back about the tobacco stuff. What happened was when the Attorney General of Mississippi took it up. He said, I'm going after the tobacco industry. And then he was able to get other states. And so the attorney generals went after the tobacco industry. And I thought, you know, who is the Attorney General of Mississippi today? So you all got me. Because I know there's expertise out here. I know there's research out here. I know there's more papers out here. And so I'm not sure we don't have the makings for going over the line. I mean, all of the work that Dr. Ray has done. My daughter's here with me, and I know yesterday when they were talking about his schedule and how he worked, and he didn't have any real free time. I'm thinking, my daughter's sitting back there saying, that sounds like Dad. And that's sort of the way it is. This stuff just gets hold of you, and you can't let it go. But, so that's sort of an introduction here. Yesterday, I realized when I got through that I may have traumatized some of you all about testifying. And some people did come up after and say, I've sort of felt a little guilty about this, but maybe, well, I needed to tell you the picture. What is the new model now? And what we're trying to develop as the new model, it's stay out of court. Get these cases settled. I mean, don't go for the big kahuna. Now, I'm from a day when we didn't fool with all the discovery and all that so much. The lawyers got together and said, what do we want to do all that? If you make a motion to dismiss, and the judge said, well, you really don't waste our time. And so it was put a jury in the box and let's see how it comes out. I love that practice. Forget all the discovery, all this falderah and going on. Put a jury in the box. That's my strong point, is juries. I love my juries. But you can't get to a jury anymore because you have judges who think that they are the judge and the jury. And so they'll block you from getting to the jury often. So you've got to default back to a model that says, get these cases settled. I'm not a good settler. I'm a righteousness kind of person. But I have somebody who is joining with me, Jed Mitchell, and he's a 48-year-old lawyer. And so Jed and I are working together in the same building, and we're down the hall from each other, and we've actually signed an agreement. And so his role in this, I'm trying to teach him all that I'm talking about here, but his role is to seek settlement first and stop as much as we can all of the fisticuffs in court. But that might still involve you all because the settlement comes when I say, if we go to court, this is what you're going to face. So I need your affidavit. I need your input. I need you to cooperate. But don't throw up this guard that says, oh, my lands, I'm going to be sitting in a courtroom. I'm going to be out of my office 5 days, and the jury's going to be scowling at me, and the judge is going to get at me. Get that out of your mind. We're trying, maybe the big case, maybe it is the attorney general's. I want to be there when the big case comes. But, and if Jed does all of his thing and he can't get it settled, then if I'm still young enough, I'd love to get in that arena. So here we are, legal strategies. And again, I've got probably more in here than you need to know, and I'm going to stop when I get to the expert witness thing, and I'm going to dwell on that a little bit, and I've got something here to refer to. But let's go through the points anyway, and I'll make a comment about each of them. In many circumstances, juries have a person that has been or knows of someone who has been affected by mold. This is both good and bad. Now, in Houston, it's been 2 years ago now, and they have this weird way of picking the jury, but they had 300 jurors sitting out there, potential jurors. And so we had to voir dire, which means ask them questions to see who would qualify. We had to voir dire the whole 300 at one time. And so you're asking a question to 300 people. Stand up, hold your hand up if you are this or that or the other. And here's 300 people out there. And so the question is, have you ever been personally affected by mold, or someone in your family has? Half of the group stood up. So we have 300 potential jurors, and here's 150 of them who have been sick from mold or who know somebody in their family who've been sick from mold. That ought to tell you something, that a bunch of people are getting hurt by mold. They're not filing lawsuits, but they're out there and they know. Well, of course, then the defense, that was their job to try to keep all of those people off, and it was my job to try to get as many of them on the jury as possible. And the system was very complicated. I'm glad I had a paralegal with me. It was more complicated than I could figure out. And she'd say, no, that one, number 35. Why number 35? Just shut up, 35. So I said, okay, whatever you say. But we got a jury, and we had some people from the petrol industry. We had some pharmacists. We had some regular folks. And the jury virtually got in a fist fight. They were divided up, and there were some in there that thought we were nuts, and there were two in there that just went to the mat with us. I had a client who, phenomenal person, very injured, but I said, you've got to dress down, because she looked like she walked off the cover of Vogue magazine, right? And dressing down, it still didn't help. The jurors were in there joking about her, calling her the princess. And it didn't help that her mother sat in the courtroom the whole time, and she looked like the Queen of Denmark. So, so those things matter. Those things matter. But two of the jurors came out of the jury room. They ran up to us in tears, I mean literally tears, and telling us what all had gone on in the jury room. And it was bad. I mean, there was jury misconduct. If we had wanted to pursue that, we could have probably made a case for jury misconduct and had a retrial. My clients were through. I mean, they had done it for years, and so they were just through. They could have gone on. But so jurors, that's a big deal, picking jurors. And it's very rare these days that people don't know something about mold. They either know it and reject it, or they know it and they've been hurt by it. So getting a real impartial jury that says, I don't know anything about this at all. What's mold? So they dig holes in your ground, right? And it's that green stuff on cheese. I eat that. You know, I like the cheese with the green stuff on it. So, but there are not many of those left. This is a major problem, and people know it, and it affects your ability to pick a jury. Juries will be flooded with expert testimony. The challenge is to help them digest the information. Now, if you can imagine regular jurors sitting in this room yesterday, what in the world is he talking about? And so getting those cookies on the bottom shelf, there is my real expert. And that's why Dr. Lipsey was a good expert. They didn't know too much what he was saying about all of his toxicology stuff, but they just like him. He's just your best uncle. You would like to have lunch with him. And so I look around, and I'm looking in the room here, who would I pick? And I'll tell you, I've got my eye on a couple of people in this room right now. They might get a call from me because they just have that stuff. They have that persona. Plus, they have the knowledge that goes with it. And they could, I believe, get the cookies on the bottom shelf. That cookies on the bottom shelf thing comes from a Bible teacher, J. Vernon McGee. I don't know if anybody if you know him, but he's a great theologian. He was a real master at his theology, well trained. But he taught on the radio, and he said, "My job is to get the cookies on the bottom shelf, because I can go in and talk about all my highfalutin theology, and it won't be worth a dime to anybody. I can get another theologian, we can sit down and have coffee and have a big time. That's not helping anybody. So that's why I use get the cookies on the bottom shelf. Dennis can do it sometimes. So you have to present it, and who the jurors feel is the stronger connection. They have the strongest connection with, that's who's going to get the verdict. Tort reform-minded jurors tend to be prejudiced against all plaintiffs. You spot them and you try your case to them. Tort reform is thankfully waning, but it had its heyday. Good gravy, the McDonald's coffee, the lady that spilled the coffee in her lap, she was the most maligned human being in this country forever. I just wish everybody could see what that coffee did to her. She was very injured. And McDonald's, you know how the jury decided to give $10 million? They decided that McDonald's should give her 1 day's coffee receipts. So it was not a big deal to McDonald's, but you would have thought she was bringing McDonald's to the ground. And then it wound up settling for $1 million anyway. So, but that was just blown way out of proportion, and it poisoned the minds of so many people that these days, when you're picking a jury, you have to say, do you know about the McDonald's case? You know about the lady that spilled the coffee and all that? And someone, yeah, that was the most, they drank the lemonade. And sometimes you can't get them off the jury. They're going to be on there, and they've been waiting a long time to get at some crazy old plaintiff. When you have one on there and you can't get them off, try your whole case to that juror. That's your whole jury right there. And I did that once. I tell this story. When I say I tried obscenity cases, I mean I tried big obscenity cases. Everybody, when I did the deep throat case, I had the actors, the actresses, all the people. And so we would have 12-week trials on the case. And I had one, and I had a really good jury. There was a 22-year-old girl sitting in the number 1 seat. She was African American, and I could tell she was very educated, and she was who I had to try this case to. So I spent 12 weeks talking to that 22-year-old girl because I knew she was going to get me as soon as she had a chance. And so the jury retired. There was also a man who was a stock guy at a department store, and he was about 65, 70 years old, slept most of the trial. He had a 12-week nap. And so the jury retired, and my 22-year-old, I don't think there's anything wrong with this. This is intruding on my First Amendment rights and all that. So the guy woke up and said, because we have to do the average person, you know. So the average person was 42 years old, who was about the age of her mother. So the stock guy woke up and he said, Missy, what do you think your mother would think about this film? She said, I got it. But I had to try the case to the juror who I knew was going to be against me. If y'all are ever trying a case, you let me know how that comes out. But you have to be aware of that. Trial stat. Expect antagonism from judges. A lot of judges these days are tort reform-minded judges. And I can tell you about, you need to learn this, result-oriented adjudication. That's what I'm saying when I say judges these days feel like they are the jury and the judge. And it's this whole deal about result-oriented adjudication. Judges adjudicate, and they decide what they want the result to be, and they make it come out that way. If they have to do it with jury instructions, if they have to do it ruling on motions, if they have to do it in Daubert hearings, they make it come out the way they want it to come out. And they feel good about it. They morally feel good about it. What all is going on in the Supreme Court right now is really big stuff. Gorsuch, Kavanaugh. If we get 1 or 2 more judges on the court, you will see result-oriented adjudication go away. Result-oriented adjudication came in with the Warren Court when they solve all the social problems in the world. And it's plagued us for 50 years. And we are not the same country that we would be if we hadn't had that experience. And it's changing. You know, I am not a big fan of Donald Trump. I am a huge fan of what's going on in America today. We are changing as a nation. And I've been through it all. I've watched it through the whole process. And if you've been through what I've been through and you know government like I have, that was my passion, was government, still is. And you watch all this and you just sit in amazement to watch that pendulum swing. And it's swinging back. But right now, we still have to deal with result-oriented adjudication. Adjudicators, judges who make it come out the way they want it to come out. So you have a big job in convincing the judge. And I want to pause on that in a minute. The primary threat of antagonistic judges is siding with the tort reform-minded jurors and making the jurors their owners. So if you get to jury trial, the judge can spot the tort reform-oriented juror, and he matches up with her or him, and then it just pollutes the whole jury. You got to be aware of this. It's not the old days. Most judges are unfamiliar with the science. You've got to get the cookies on the bottom shelf for the judges as much as you do the jurors. But they are able to see this is a real threat. You know, people are dying. Yeah, they're dying. And so it's been going on for this long, and why hadn't I known it, et cetera. But you really have to win their hearts before you get their rulings. That's part of a result-oriented judge. You got to get his heart because he's ruling or she's ruling from her heart, not from the law. I never wanted to be a judge because I needed more reign. You know, a judge is somebody who is supposed to live in a corridor, and it's a very narrow corridor, and the walls are electrified, and the corridor is precedent. You look at the precedent. You may hate the result, but you have to say the result is what the precedent says it is. And you can make a speech if you want to and say, I think this is the most horrible decision. I think it's unfair. I think it's unjust. Whatever you want to make your speech about, but I have to rule this way. You used to see those decisions a lot. The judges would say, my hands are tied. I can't do anything else. Because that precedent was there and it was electrified. If they bumped up against that wall, they got shocked. If they bumped up against it, they got shocked. Somebody's torn those walls down. And so it's a new day. Judges are not as petrified of bumping into the wall now as they used to. They're influenced by presentation, credulity, demeanor of the experts, etc. Let's see, the critical issues. The two-tiered causation factor. You have to show that mold will hurt the population generally. Anybody who had been in the shoes of these plaintiffs would have been injured by this mold or these mycotoxins. It can't just be something that injures the plaintiff. And so that creates a problem because only what percentage of the population is affected? 25% I've heard. Basically, I've heard we don't know, but we know that more of the population would not be affected than would be affected. So you have to overcome that and say there's a significant enough portion of the population who would be affected if they were in the like and similar circumstances of these plaintiffs. And then you got the second tier. You have to prove that this mold in this place injured these plaintiffs. And then you get the ubiquity factor. Mold is everywhere. How do you know, Dr. Hooper, that the mold that was in that apartment hurt this lady? And we just had to go with, well, there's too much similarity, etc. Now he says, me. And then yesterday I'm hearing, no, not Ermi, but yes, Ermi. We have to rely on Ermi to make that connection, but that's a really important connection. The ubiquity factor is always the big deal on the defense. It's everywhere. Everybody gets it. And there's this huge propensity to try to equate outside mold with inside mold. So you have to overcome that barrier. Mold in the atmosphere and mold at the wherever, that's not the mold we're talking about. We're talking about the mold in a confined area that's toxigenic. And it shouldn't be there. You shouldn't have Stachybotrys in your house. That just shouldn't be there. And so you have to deal with that. And the non-universal effect, I said that. Now, these are cases, if you were a lawyer, I would say, don't do anything. Don't ever get out of your cubicle to try a mold case until you've read these cases. These are beautiful, beautiful cases. And Jones versus Steve Jones Auto, that was a situation. It was a workers' comp case, actually, and there's a lot of workers' comp stuff to deal with, and that's good for that reason too. But you had the typical answers. You have ubiquity, and you have all of the issues you face in all of the cases, and it came out right for the plaintiff, quite right for the plaintiff. And you had experts from Duke, and that's where I got into the Duke experts and the people at Duke that are really doing some phenomenal work on mold. And it seems like nobody knows about what's going on at Duke. But that's a good case. Cornell is a good case. Krug is a good. Rosati is a good case. Grenier and Frazier. Now, Grenier is the best I have ever seen. So I'm going to spend a couple of minutes on Grenier here. This is a case that involved a mother and a daughter in an apartment, and they got really, really sick. Now, the injury occurred in 2005. The decision came down in 2014, mind you. It never saw a jury. It ended on a summary judgment. When I say summary judgment motion, I mean somebody comes in and they say, the plaintiffs cannot win because these are undisputed facts, and these undisputed facts will prevent their experts from testifying or will prevent them from proving causation. And so the judge is called on to say, yes, the plaintiffs cannot win because their experts cannot testify because of reasons I'll tell you, or they can't prove that this mold caused this injury. Well, so it really got down to experts. Who is the most qualified expert, or who has testimony that can be presented that could win the day? Now, this judge, she's a young woman, she took 1 solid year to write her opinion. You don't see that very often, but she wrote her opinion, and she took it expert by expert by expert, and she compared the testimony of everybody, and she compared the undisputed facts about the injury. So I've written up a case synopsis of this case just because it's so illustrative of what should happen in a mold case. So first, though, neither Ipsy-Dixit nor the analytical gap, remember that, the analytical gap. Courts talk about the analytical gap. Okay, Mr. Expert, I follow you A, B, C, D, and then I'm over here to H, and there's this gap. You can't connect your dots from D to H, and that's called the analytical gap. And if you have an analytical gap in your testimony, then your testimony will probably not be accepted. So you have to be able to tie it together. Otherwise, they say, Ipsy-Dixit, thou shalt leave. Because essentially what you're saying is, you are saying that it's true because you said it was true. You don't have your dots all connected. So before you get on a witness stand, you need to connect your dots. Avoid the analytical gap. Well, It appears in the text of the opinion. The opinion is all about both, ipsy-dixit and the analytical gap, but not once does the court mention either one of them. A duly credentialed expert's opinion is not admissible if it's ipsy-dixit. That is, stated without reliable and reliably explained underlying support for the data and from the data, and that it is generally accepted methodology and technique applied to the data, combined with the support and to be synthesized by reliable scientific evidence. The scientific literature. So you've got to have your data. It has to be data that is accepted generally, and the method used to analyze the data has to be generally accepted. And then you have to synthesize that with the literature. You are good if you can do that. By good, I mean you're in. So the opinion verifies, this judge found, the opinion verifies that there is a sufficient quantum of reliable literature to support the opinions of duly credentialed experts that toxigenic mold, that is, mold capable of producing mycotoxins, can cause the neurological disorders and immune system dysfunction. So she said, the judge said, I hear the experts on both sides, and there's enough here to support that these mycotoxins can cause these conditions in these people. So the whole theory of the summary judgment motion by the defendants was three-tiered. And it was, the opinion verifies that the naysayer testimony, that is defense testimony of credentialed defense experts, and here's what they normally say. There is nothing in the literature, there is no authoritative literature, or there is no support for, or so that's their main things there. There's nothing in the literature that supports this. And there is no authoritative literature on this. It's not in the New England Journal of Medicine. And in my experience, you hear this from defense lawyers, defense experts. In my experience, I have never seen, I've never heard, I've never had a colleague. I have to cross-examine those people, and they're really easy. Because I had a neurologist not long ago. He was a professor at the University of Texas Med School. And he had just brushed up the night before. He had gone on PubMed or MedPub or whatever it is, and he had pulled out a few things. And he had been in Vietnam. And he was on the battlefield in Vietnam, and he had seen lots of mold on those soldiers over there. That's all he had. Well, he is duck soup as far as my ability to examine him, because he can't meet the criteria himself. And so by the end of his deposition, he was going, okay, are we through? So they're easy. The defense witnesses are often very easy to handle if you know what you're doing. If you're a lawyer and this is your first mold case, you're dazzled by this professor from the University of Texas Med School. But you learn to deal with that. Well, she went through, the judge here, and I just will refer to, I was reading the wrong part here. Here's the reasons why the summary judgment was filed. They said exposure to mold causes the types of illnesses suffered by Kiko and Maya. They were saying you can't prove general causation. This mold, this is an idiosyncrasy. This mother and this daughter are suffering not from a condition that other mothers and daughters would suffer from if they were in the circumstances. Any opinion to the contrary is not generally accepted as reliable in the scientific community. That's a pretty strong case, the scientific community. And then the third was, even if to a reasonable degree of medical certainty, the molds in question can cause the illness in humans, general causation. It cannot be proven to a reasonable degree of medical certainty that the mold in that apartment caused these injuries. So how many experts were in this case? I will read the names of some of them. You may know them. The defense experts was Frederick Gurr, MD, S. Michael Phillips, MD, David Snyder, MD, Eugene Shapiro, MD, Ruth Nass, MD, Jerome Block, MD. That's how many defense experts came to testify that it wouldn't work. So the literature, the defense literature, I mean, it goes on for, well, they relied on about 10 pieces of literature. I could read them off. You might be familiar. The plaintiff's experts, Michael McGinnis, certified industrial hygienist, Irene Grant, MD, and that was about it. So you had that array of defense against these two, one CIH and Irene Grant. I don't know how many of you know Irene Grant. She's sort of her own person. But let me tell you, that woman is some testifying with. She mowed them all down. She mowed them all down. And she testified, I could go through all the things she testified to, but there are things that you could testify to also, probably. And the judge said, you can't combat that. And Irene Grant has not published one thing, not one thing. And she's read literature. She's pretty much up on the literature, sort of, kind of. But she has treated thousands of patients. And so her credentials came from the fact that I have collected all of the data of my patients over 10 years. And I'm testifying to you from what I have learned from treating 10,000 patients, or however many they were, a lot of them. And so she starts getting cross-examined about, okay, tell me about the 10,000. We can stay around here a while. What's the first one you treated? What's the second one you treated? I can't remember all that. I don't have the time to collect all of that data and bring it in here to you because I'm too busy treating patients and making people well. But I tell you, it's in my head. It's in my head. And I am absolutely certain. I'm not certain just to a reasonable degree of medical certainty. I'm absolutely certain of what I'm testifying today. So that case, if I had one of you all and I twisted your arm and kicked your ear in enough and you said, okay, I would make you read this case and just see how it can be done. And it can be done. And the case settled. After the judge ruled that they couldn't win on summary judgment, that was enough.
Yeah, I'm Gus Gutsanis. I practice in integrative medicine in Grapevine, Texas. And one of the things we're trying to do lately is take patients that have seen everyone, tried everything, and everything has failed, and they come to us for help. So the choices are very simple. I say, the standard of care says you need this drug, which they have tried, they have failed, or go home and die, or do what I'm telling you. And we know that what we do works most of the time because they have no other choice. Because if I do not accept to treat them, they will travel to Mexico or Germany or South Korea for treatment. So how do I defend myself against the board?
How do you defend yourself against the board?
Yes, sir.
Well, I got more familiar with the Texas Medical Board than I ever wanted to get. Because in my first case, my client had consulted Andy Campbell. And so he was the only one I knew, and I talked to him a lot. And I didn't know what he said was good with me. And And I remember we were in court one day, and the defense said, well, Dr. Campbell has charges pending against him from the Texas Medical Board and yada, yada, yada. And the judge said, have they been proven? And I said, no, they're still going. He said, that's all I want to hear about the Texas Medical Board. But then I had to have him later, and he was the treating physician for another client I had. And she loved him dearly. And then that Texas Medical Board stuff just kept coming and kept coming. And he had the best lawyer I know. I mean, he could not have had a better lawyer than Ace Campbell in Austin. But he had to fight those people off, and he fought them and fought them. And Ace would appeal and win, and it would come back and appeal and win again. And he ran out of money. He just couldn't do it. And Ace couldn't go on for free. And so they suspended his license. But it was all, he brought in the best witnesses in the country to testify at his hearing. The medical board could care less. It was a stacked deck from the beginning. And, you know, I just have heard about Dr. Ray's experience with them, and he seems to have gotten a wrench around them. But that was a crooked bunch of people, and I don't know how you defend yourself against that. If somebody mentioned that there was legislation pending or might be pending that would give you a de novo hearing in the circuit court, so you could go out from the Texas Medical Board, you go get a de novo hearing. That means a new trial and even a jury. And if that happens, the Texas Medical Board's out of business, because Ace won every time he went to the court, but the court was very limited in what it could do.
Yeah, do the patients have any rights in Texas?
I didn't understand what you said.
Do the patients have any rights in Texas?
They should, yeah, they should. But Dr. Campbell's patients were testifying for him. He only had one disgruntled patient who obviously was, and I had to go through every line of those whole proceedings, all the depositions, all of everything, because then I was taking his deposition. And like I say, I get proactive, so I took the deposition. I said, well, okay, Dr. Campbell, let's go through the Texas Medical Board. And it took 3 hours to go through from witness to witness to pay. And I talked to Ace Campbell lots of times. He said, I've never seen anybody so persecuted in my life. And Ace wrote the statutes. He was not he was very familiar with what he was doing. Yes.
Richard Jakely, Dallas Psychiatry and so on. And I hear you saying two things, and maybe this is my problem. I listen too much. I hear you saying avoid getting to court, settle, but then I hear you looking for the big case.
Well,
now, I have some contact with the Mercury problem, and I told that consortium, there were over 40 attorney groups in that consortium. And I was studying with them and so on, and I finally got to the point where I said, I don't think you have a case. And the head of it walked out of the room, and then he came back and said, well, we don't need you anymore.
well,
and if you say anything about this, you know, we're coming after you.
Yeah.
So, you know, which are you saying? Are you looking for the big horse, or are you saying avoid this?
Well, I'm saying, and I tried to say at the beginning, I'm such a trial lawyer type that it's hard to keep me from talking about how to do the trial. But what I mentioned about the new model, that is, get these cases settled before you ever have to file a lawsuit. And there's a methodology for doing that. You call the lawyers on the other side. You say, okay, your employee is in my office, and I have talked to your employee, and et cetera. And then you say, we don't want to go to court. You don't want to go to court. So let's work something out. Or sometimes it's the employer who's in an office building that's owned by somebody else. And we say, look, it's not really your problem. It's the owner of the building's problem. And you and your employee really have something in common. So you just do everything you can to make this settle in a way that is acceptable to your client. And you say to the client, you really don't want to be in court for 10 years. You really don't want to spend $100,000.
I asked you this yesterday, and that's why I'm glad for your elaboration.
Yeah, and Jed Mitchell standing over here, it's not any accident that he's positioned himself there.
He wants to try. I want to settle.
So he's the lawyer. He and I are working together. We're going to make him the settlement guru. And yeah.
Does it make any difference on the defense side how deep their pockets are? You know, because some of these are, you know, these mega apartment complex consortiums, right, and they have very deep pockets and a lot of lawyers. Does that make any difference in your cases?
It does make a difference. And there's a way to deal with those people. They can spend you out of court. There's just no two ways about it. I mean, I had the misfortune one time in a prime rate fraud case of subpoenaing David Rockefeller. Well, why not? He puts his pants on one leg at a time like everybody else. And this was before email and all of that, and before FedEx. And the next day, which I think was a Sunday, I had people at my house from a law firm in Miami. I had people from a law firm in New York. And I said, I don't care what his name is. He's the one that did it. Well, so I wound up in New York City arguing the motion to be able to take David Rockefeller's deposition. And I didn't, but the judge almost let me. He almost let me do it. But yeah, with that kind of firepower, you can't stay with them. And but there are ways to deal with them, and there are ways to settle with them, because they also don't want the cat out of the bag, my friend. If they have an apartment dweller at one of their apartments get a big judgment against them, doesn't matter how much money they spent on the defense, that cat is out of the bag, and their apartment people are going to be coming, so they really, really want to settle. So if you get in your mind that you don't really want $5 million, you want some amount that's relatively, well, you figure out what the cost to them is of losing, and convince them that you can beat them. They don't have a shoe-in here. And so that's what Jed's going to be doing, is trying to say, we've got something in common here. Neither one of us want to be in court. And so, but they can make life miserable for you. Now, if the big law firms, the big plaintiffs' firms were taking up this thing, they'll stay with them. You can't outspend the big plaintiffs' firms. But the big plaintiffs' firms on the mold cases, they say, not enough sugar for a dime. I can do a med mal case. I got them under control. I can do a nursing home case. I've got them under control. There are too many spinning wheels in them. And as soon as we get all those spinning wheels not spinning, they'll come in, the big law firms will come in. But I'll say this, if you have the largest apartment complex in the world, if I can get the 3 or 4 attorney generals of a state, no problem. You know, when I was with the federal government and I was a federal prosecutor, dollars meant absolutely nothing to me. If I needed to spend $1 million on my case, then nobody ever asked. I just said, I need this, I need this, I need this. And so there's a way to whip them.
I get asked a lot when I'm out and we're assessing different locations, how much mold is too much mold in my house? And when we're dealing with landlords and renters in the state of Texas, and I know in the other states as well, there is no statute of limitations as to say this is how much and whatnot. And it's one of our, as an assessor, it's my job to basically set the health standard for that family. But when it comes to their legal pursuit, it's not quote unquote scientifically proven that indoor air quality affects your health. It's proven outdoors, but we spend 90% of our time indoors. You know, what is it going to have to take to get some of these state governments on board with, you know, setting some type of standard?
Well, I don't know, but I don't know that I want them setting standards because, you know, I worked for the Federal Trade Commission for a couple of years, and if you want to know who owned the Federal Trade Commission, it was called Sears Roebuck and General Motors. And so when they're setting standards, I get a little scary about it because I was a young lawyer and I was working on all of these pricing frauds and all this stuff, but I realized, well, Sears stopped that 4 years ago. They're on to some other fraud now. So the agencies just stay behind, and also they are highly influenced by the big doers. And so I think the standards are enough. You know, any mold is too much mold, right? Any Stachybotrys in your house is too much Stachybotrys. And I can make that case pretty strongly. If I got a sick person who's got trichothecenes, so how much is too much and how much is not enough? Or I'd just say if you're talking about truly toxic molds, any is too much. The case I'm going to California on Monday morning, I've got 7 people in one family, and all 7, you talk about what is the proportion of the population, to find all 7 members of this family deathly ill, and with their landlord saying, well, there's a little mole in here, but I don't think it'll hurt you. Well, it's hurt these 7 people for the rest of their lives. And finally, the 13-year-old little girl who had not been able to go to school for 5 months. And how much is too much in there? No, I think the proof is in the pudding.
All right, we'll have to stop the Q&A session. Again, like yesterday, we'll have more Q&A after the speakers this morning. Thank you, Larry.
Thank you.